Good morning. This is your Kelso Report for Wednesday, January 23rd. I'm your host, Clark Kelso. In our first case today, the United States Supreme Court placed limits on the circumstances where a litigant against the government can invoke equitable tolling to avoid an internal administrative statute of limitations. Then we have a decision involving an arbitrator's failure to disclose a conflict of interest, and a case involving the validity of a donative transfer under a will where the lawyer who drafted the will was related to one of the transferees. Let's begin with the United States Supreme Court. As a general matter, the federal government is usually not susceptible to the offensive use of the doctrine of equitable estoppel. It is said that you cannot estop the government. Well, this general rule is grounded in the federal government's sovereign immunity and the corresponding principle that the government may be held liable only if it has waived its sovereign immunity. However, the Supreme Court has carved out an exception dealing with the doctrine of equitable tolling of statutory limitation periods, where the court in some cases has explained that notwithstanding the absence of any express statutory language adopting equitable tolling, it is likely that statutes involving claims by individuals who are unsophisticated litigants, it is likely in these cases that equitable tolling is consistent with congressional intent. Well, in Sebelius v. Auburn Regional Medical Center, the court faced the question whether the equitable tolling doctrine applied in the context of an internal administrative appeal by healthcare providers seeking to challenge the initial determination of the reimbursement due them for inpatient services rendered to Medicare beneficiaries. Now, under the Medicare program, government contractors, called fiscal intermediaries, receive cost reports annually from care providers and notify them of the reimbursement amount for which they qualify. A provider dissatisfied with the fiscal intermediary's determination may appeal to an administrative body named the Provider Reimbursement Review Board. The governing statute sets a 180-day limit for filing appeals from the fiscal intermediary to the PRRB. By regulation, the Secretary of the Department authorized the board to extend that 180-day limitation for good cause up to 3 years. Well, the providers before the court are hospitals who appealed to the PRRB more than 10 years after the expiration of the 180-day statutory deadline. They had filed their appeals after one provider, not before the court, who had challenged its reimbursement calculation within the deadline back in the 1990s, finally won its appeal after almost 10 years of litigation. We then had a bunch of follow-on providers who suddenly challenged the 1990 calculations, asserting that the Secretary's failure to disclose information that made the fiscal intermediary's reimbursement calculation incorrect prevented them from earlier appealing to the board. Well, the Supreme Court unanimously held that the statutory 180-day limitation was first not jurisdictional, so the Secretary could extend it to 3 years, but that the court would defer to the Secretary's reasonable construction of the statute to permit only a 3-year tolling for good cause. But because the appeal in this case was an internal administrative appeal, and the case involved sophisticated businesses, which can be presumed to have the wherewithal to protect their own interests, the court rejected application of equitable tolling to get you beyond the 3-year period. So the providers in this case were about 7 years too late. Their actions were dismissed. Next we have an arbitration case, California Court of Appeal. One of the most fundamental aspects of due process is the right to be heard by a disinterested judge. Even in the privately negotiated world of arbitration, a neutral decision maker is a key protection to all parties. In Gray v. Chu, the 2nd District confronted an odd situation where the parties to a medical malpractice arbitration agreed upon a neutral arbitrator, and then, subsequent to the commencement of the arbitration proceedings, but prior to the arbitration hearing, counsel for the defendant doctor affiliated with the firm providing the neutral arbitrator. Neither counsel for the doctor nor the arbitrator disclosed that relationship. Well, applying the relevant provisions of the California Arbitration Act and the California Ethics Standards for Neutral Arbitrators in Contractual Arbitrations, the 2nd District held that it was required to vacate the arbitration award because of the failure to disclose and the rather obvious conflict of interest. Our third case today also involves possible conflicts of interest, this time in the context of the drafting of a will. In Estate of Lira, the will and trust of one Olegario Lira named his 3 natural children and 3 of his 6 stepchildren as beneficiaries. The will was drafted by one of his step-grandsons, who was a lawyer. Olegario's natural daughter challenged his will and trust, arguing that the donative transfers to his stepson beneficiaries were disqualified under Probate Code Section 21350 because they were related to the lawyer who drafted the will and trust. In opposition, the successor trustee of the trust claimed the disqualification did not apply because Olegario was also related by marriage to his stepson beneficiaries, and therefore an exception in Section 21351 to the conflict rule applied. Well, between those two choices, the 2nd District agreed with the trial court that the transfers were valid because the Section 21351 exemption applied since the transferor and transferee were related at the time that the transferor executed the donative instruments through marriage. And the facts of this case, after the will and trust had been executed, but before his death, they had become divorced. But the court held that didn't matter. The key thing was that at the time of the execution of the donative transfer, there was a relationship between the transferor and the transferee. And that's it for today's Kelso Report. Have a great day in the law.